Okay, I think we are good to go. Okay, good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of Wills and Advanced Legal Planning, Part 1, and Why Do You Need It? My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us on behalf of our presenting partner with Lone Star Legal Aid, we have Ms. Jessie Campbell. Also included in our partnership, we have the Earl Carl Institute, Houston Volunteer Lawyers, Texas Legal Services Center, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And A Month of Service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, information to the communities that we all serve relative to asset building, asset protection, the maintaining of generational wealth, and community empowerment. In today's presentation, we're going to be talking about wills and advanced legal planning. This is the first part. The first part is about why you need it. The second part is how to draft your own will and transfer on death deed. So we alternate those two from month to month. But we do this presentation along with all of our other ones in an effort to reach more people, to create a larger impact, and get as much information out to the communities as we possibly can. And today I am hosting live or being hosted in person at the South Union Place Apartments over off of Scott Street. We got the request to have us come in and do the session in person because a lot of folks that were here before had attended, and they asked us to come back and do the session here in person because they actually had some other questions that they wanted to ask. So we try to do that little bit of outreach and make sure that we try to get back out in the community as much as we possibly can. We're going to be in 2026 doing a few more of those in person along with the virtual sessions as well to try to get back out into the community. We used to be out in the community on a monthly basis with all of our presentations, but of course, due to the pandemic, we had to transition to the virtual platform that allowed us to reach more people, to create a larger impact, reach people outside of the city of Houston, outside of Harris County, surrounding counties, and across the entire state of Texas with the information that we have to provide for you. So these presentations have evolved over the last several years that we've been doing these, and it's due to the feedback from the people in the community when they reach out to us if there's a topic or some information that they need more information or something that they need more information about, then we try to make sure that we have make that information available and do a presentation. So for those that are just joining us for the first time, we want to welcome you and thank you for hosting us here today. And just giving us that opportunity to continue to provide a service to the communities that we serve. And we want to thank you guys and appreciate you for your continued support. And for those new folks, we want to welcome you and thank you for joining us today. So with that being said, there's going to be a lot of information that's going to be covered here today. By no means do we expect you to be the experts by the time you leave here, but at least you'll get a little bit more information, a little bit better insight so that you can help inform other people in your community, your other family members, because there is a lot of misinformation that's out there. There's a lot of information that's floating around on social media platforms. And people assume that some of the statements that are made are also relative to the state of Texas. But the information that's presented here today is about how the process works in Texas. So do not listen to the street committee that's out there kind of just giving, general information to everybody, or, oh, when I did it and this is how, it happened for me. Everybody's situation is completely different. It is not the same. It's not going to work the same. The process is the same, but everybody's situation is not the same. So what one path that one person takes, it's not going to be exactly the same for the next person because, your assets are different. The family makeup is different. All of those kinds of things are different. So it happens differently for different people. So This is your opportunity to ask whatever questions it is that you may have. We do ask that you try to keep your questions to be as general as you possibly can and not get too specific or detailed with the information or with the question that you may have for your particular situation. Because we are on a public platform, there's a limit amount of information or a lot of response that she can actually give to you guys. Do know that the information that we do provide here is for educational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners and apply for their services like with Lone Star Legal Aid. So you do have the opportunity to do that. And Ms. Campbell's going to provide that information for you guys as well as how do you do that and reach out to them. Um, the documents that she goes over throughout this presentation, I will be sending out copies of each of those templates. I don't send them out in advance because there is a lot of information that's covered. And to have you try to look at the forms and the documents as she's doing it, it gets a little confusing. And again, it's a lot of information that's going to be covered here. This session is being recorded. We do also send out the link of the recording for you to go back to actually view. So when you have the documents with you, you can watch the recording at the same time so that, in case um, you're interested in doing your own documents or, you'll become a little bit more familiar with them. So do note also, in addition to the recording, we do broadcast live on our social media platform. So again, we want to try to protect your privacy as best as we possibly can. So we ask that you try to keep your questions to be general and don't divulge any personal detailed information for everybody to have access to. So do keep that in mind. But again, we do encourage you to ask questions. If you're joining in person, feel free to speak your question aloud and I'll make sure that she gets it. Otherwise, you can feel free to type your question into the comment section. Thank you very much. Type your question into the comment section. If you are joining us on social media, feel free to type your question into the comments. I am monitoring that as well, and I'll make sure that your question gets addressed at the end of the presentation. So without any further ado, we're going to go ahead and get started and have Miss Jessie. You're going to introduce yourself and we're going to get started.
All right, fantastic. Good afternoon, everyone. Give me 1 second to get all my stuff shared. Okay, here we go. All right. Thank you again for attending. My name is Jessie Campbell. I'm a directing attorney with Lone Star Legal Aid. And I am going to be presenting today on legal advanced planning and what it is and why you need it. As Ms. Nia was just saying, there's a lot of information that gets covered in this. A lot of this has been built off of questions that we have received over the many presentations that we have done. And so trying to get all the information that you need, but also recognize that you're not going to remember all of this, and that's okay. The recording will be made available to you, so you can go back and take a look at it. And we're like, oh, I don't remember what she said about this. You can go back and take a look at the recording. All right, and again, all of the templates will get shared with you after the fact, so you don't have to worry about like taking screenshots or anything of the presentation as you are going forward. So first, a little bit more about Lone Star Legal Aid. We are a legal aid provider. We serve 72 counties in the eastern and Gulf Coast region of Texas and 4 counties in southwest Arkansas. Around Texarkana is our Arkansas counties. We have currently 14 offices, including our Houston headquarters, which is where I am, as well as these branch offices throughout our service area. We serve financially eligible clients, and that's based on the size of your household, your income, and your assets. I wish I can tell you, I can say, oh, it's this amount of money that you make, and that's going to make you eligible. Unfortunately, it's a little bit more complicated than that. But we do have quite a few people in our service region who are qualified for services. So I say if there's a possibility that you qualify, go ahead and apply. Don't rule yourself out as being ineligible because, again, just, it does depend on a lot of different factors when we're determining eligibility. We do a lot of different types of civil legal matters. That includes consumer, housing, family law, estate planning, just to name a few. We don't do anything that is criminal, personal injury, and driver's license and tickets. So those are the types of things that we don't do. But on the civil side is where we are, and that's my website and phone number. It's also right here for those of you who are watching. So disclaimer, this is for educational purposes only today. I'm not here to provide you with legal advice. If you have a specific legal need, we do recommend that you contact an attorney and ask those questions directly to that attorney, or if you think you qualify for services, to apply for services with either with me, Lone Star Legal Aid, or with one of our partners to be able to provide that with for that. That brings up and a repeating of the questions. This is on the internet. This is everywhere. This is broadcasting live right now. For those of you who are in the room, there's other people listening to what you have to say. Please do not share any private information during this conversation that we're going to be having today. We do not want any bad actors to get hold of some of this information and be able to do something against you. And also, it's private. We want to be sure that you keep your information private. So the other factor is I cannot provide legal advice today. You must be a client of Lone Star Legal Aid in order for me to advise you. And so if you are asking me a question that's very specific to your situation, I will not be able to answer that. I can provide general information about the law in hopes that it will help you conclude an answer for yourself, but I cannot answer any specific legal questions about your individual situation. So one, protect your privacy, protect your information. Two, I probably can't answer the question anyways. But I am pretty good at answering questions in the chat as we go. So for those of you who are on the Zoom with me today, you can type your questions into the Zoom chat. And I will answer them as I go, assuming that it fits wherever it is. But don't worry, for those of you who are watching this online or are in the room, we will have time for questions at the end, and we will be able to ask questions at that point in time. Okay. All right. So with that, let's get going into this topic. So our agenda today, we're going to be talking about the principles of estate planning, the specific types of estate planning documents, and then the available resources. The majority of our time will be discussing planning for death. That is the biggest topic, but don't worry, we will cover everything as we go forward. Okay. So first, important terminology. What is the difference between advanced planning, estate planning versus probate? They are not the same thing. So you may hear some attorneys will refer to advanced planning or estate planning. Those two, that can be interchangeable. Advanced planning is preparing and planning for death, incapacity. So incapacity is when we are no longer able to make decisions for ourselves. That is what is defined as incapacity. The care of minors or adults living with disability under our care in the event of our death or incapacity, and then long-term care. And then putting all that decision making into a written, legally binding document. That is what advanced planning is. It's the before death happens, before incapacity happens, before the need arises. Probate is the process, the legal process of handling the estate after a person passes away. And so that is what the probate process is. It's a legal court process. It's filing an application in court with an attorney. It's paying off the debts owed by the person who passed, conveying property ownership according to the terms of the will or according to state law if there is no will, and then managing issues for individuals under legal care. Again, those minors or adults living with disability that were under our care. What happens in that court process depends on what advanced planning documents exist prior to death. And so I will not be talking about the probate process today. We're going to be focusing on advanced planning. I will talk about probate to some degree because you need to understand what happens in probate so that way you can make your thoughts and plans towards writing your will. But just if you're going to call if you're here because someone has passed and you have some questions on what to do there, I'm going to advise you to come to our complimentary program, which is with my good friend, which does talk about the probate process and clearing title, and you will get an email with the schedule for that as well. And so, but that's the difference, right? Now, probate is when a person passes away. What's not on here is that there's also a procedure for guardianship when a person is permanently incapacitated. And that, again, is a court process on taking care of the person who's fully is permanently incapacitated, making sure that their affairs and their health are being cared for. So for everything that we have, there is a death side of things, and then there's an incapacity side of things. Right. So a key takeaway, which is kind of at the beginning part of it, but also the reminding at the end part of it, someone must do something after a person passes away. And that something is speak with an attorney. That is the thing that needs to happen. It's a lot of misunderstandings around what has to happen after a person passes away. Some different things that get said on, social media or even on the news. And so people kind of get a little confused about that. When it comes to what happens after a person passes away, it's very specific to that individual. It's specific to what kind of documents they have. What does the will say, if there is a will? What's included in that will? What kind of debt is had? Type of property that is owned? What is owed? There's so many different factors that impact what has to be done after a person passes away. And so the recommendation is to go talk to an attorney about it. But don't assume that just because a will has been written, that that's all that needs to happen. Something has to happen, and you need to talk to an attorney to figure out what that next step is. The other thing to kind of consider as we're going through all of these documents is that this is an individual plan, which means that what works for you is not necessarily going to be the same thing that works for your neighbor. And so, your family may look the same. You may be both married, you have two kids, they're both adults, and you can't just be like, oh, neighbor, here's my will, take it and make a copy of it for yourself, just change out the names, because we take into account what's different in each situation. And what just because you may look the same on the outside doesn't mean that behind closed doors everything is the same. Factors that impact what you will do in your estate planning, your family members, and the dynamics. There are people who don't get along with their families. There's disownment. There is, that can happen. There's also new family. There could be family dynamics that changes, right? Like I, have friends whose our first cousins are just like siblings to them, but like according to the law, that doesn't have the same legal impact has a sibling, right? And so, but maybe that cousin is viewed as a sibling. So we want to take into account what's going on in your individual family and what needs to happen to be able to kind of consider that. The type of property that is owned, right? Is it do we have a house, car, in other types of property? Is there debt on that property? What is owed? What, who is inherit, so like we look at what the property is, and then sometimes something that will work will not work for somebody else. So you want to take a look at that. Who is inheriting it? That has an impact. Generally, minors do not um, uh, inherit under Texas law, but they do own it, but it's held in trust for them until they reach a certain age. But other factors to kind of consider: is the person inheriting the property a person living with a disability receiving government benefits? Sometimes people don't think about that. An inheritance can disqualify that person from being eligible for their benefits. Doesn't mean you don't want them to inherit it. Of course, you want them to inherit it, but there's things that we have to do. We have to plan for to make sure that they are not disqualified from their government benefits because of this inheritance that they're receiving. So again, those are things that you would kind of want to take into account. Your current health condition, that's going to impact, especially on the health planning side of the advanced planning for health needs. But also long-term care, long-term health conditions. Is there a family history? Do we know something is coming? We are in early stages of a diagnosis, but it's going to be years before it kind of happens. So those are things that you're going to want to take into account. And all of that, again, is very individual. When to update your documents. I'm a lawyer, so I'm going to tell you that, I always joke that I'm kind of like bad news Jesse. Like I'm like, oh, here's the bad news. But really, as soon as you are aware that we all pass away, that then it's time to get a will. So, in my mind, you're 18 years of age, you should get a will. You should have your advanced planning done. You should have your power of attorneys in place. So that is my personal opinion. But once you have that first step, so if you don't have your documents now, today is your message. You need your documents right now. But you do want to make sure that they are still current, that they do meet your needs as your life changes. And so things that are going to impact your estate planning documents are going to be marital statuses, changes in marriage, widowhood, or divorce. Children, not only has children are born, it has, but also sadly, some people do lose their children as children pass. And then as they grow up, as they become adults, and are they living with disabilities after they turn 18? So health changes, and then of course major property changes. Now, major property changes I describe as being like big ticket items, things that usually have some kind of a legal document that supports who owns the property. So that's going to be like your car, land, houses, boats, those types of things you're going to want to take a look at to see if you need to do some advanced planning for that, because they are property that has some type of a paper, a documentation that shows who owns that property. So you want to be sure that that's kind of incorporated. It also can include things that are sentimental value or other high valued items, right? So if you are a person who inherits family property and there's like a family heirloom that's been going on from generation to generation, and now you're the person who is the caregiver of that property for now, right? Like you would want to be sure that that is updated and included in your documents to ensure that that tradition continues on. So those will be kind of like some examples of property changes that we're kind of talking about. Right. In all of these documents, I'm going to be talking about a person that you're going to be choosing as your representative. They all have different titles depending on the document that they have, but they all are effectively doing the same thing. You are picking a person who's going to be acting on your behalf when you are unable to do so due to death or incapacity. That's what it is. It's a person stepping into your shoes under those conditions, whatever that document is planning for, to handle your affairs, to take care of things for you. And so when you're selecting someone, you want to be sure that it's someone that you know and that you trust and will do what's in the best interest or as you would do if you were available to make those decisions. This is not necessarily the same as who would be the natural choice. And I say this because we love our families, right? We have good relationships with our spouses, our children, and we love them, and we don't want anyone to think that we don't trust them. This is not the same thing, right? And so when you're picking a person, recognize that they are going to be doing something. They have been given legal responsibility to act on your behalf. When we're talking about a will and naming the executor, that's who would be handling the affairs. There's a lot of work associated with that. That is going to court at least one time. It's working with the attorney to write a new deed for the inheritance of the property, doing final tax returns. So there's just kind of like these things that you got to do. It's paperwork. It's a lot of paperwork, and so you want to be sure that you pick the person, and this is just an example. We'll talk about all the other documents and then picking those people. You want to pick a person who's going to be able to do that. Now, that may be your spouse, that may be your oldest child, but recognize that that is kind of the ask that we're asking of them. And it tends to be a very emotional decision. I'm not saying it shouldn't be, but you want to be sure that when you're picking this person to say, hey, this is what I'm asking you to do. When I am gone, I need you to go talk to an attorney. Remember, takeaway number one, go talk to an attorney. I need you to take this documents and go talk to an attorney to see what needs to happen. And, you're going to be paying off my final bills. You're going to be doing a tax return. You're going to be writing some deeds. Well, you're going to do whatever the attorney tells you to do. And so recognize that that needs to be a person who can handle that. And maybe that's your brother Bob as opposed to your daughter Susie, right? So it's, so kind of think about like who's going to be able to do that, and who's going to have the emotional ability to deal with some of that. On the medical side of things, making medical decisions can be very difficult because how do you separate your emotions from the medical decisions that need to be made for someone that you love? And so, again, not saying that they shouldn't be, but just be aware that you want it to be the right person. Select one person. I was in one other presentation about this for attorneys, and I thought the way that he described it was absolutely perfect. Do you want two people driving a car at the same time? That's effectively what happens when you have two people doing that. One of the reasons why you want to have advanced planning documents in place is to avoid any conflict that might happen in the family because because people might have a different idea of what needs to happen. And so when you have that conflict and they both have the same authority, who's going to be the final decision maker? Who's going to be able to decide that? And sometimes that may be a court, and maybe you have to file something in the court, and now the judge who doesn't know you great judges. We got great judges. I'm not saying that they aren't nice people and will not do what they think is in the best interest according to the law. But it's still someone who doesn't know you, doesn't know the family, right? And so, and who's not going to have the benefit of the years of experience and relationships that have been built among with you and the person that you've chosen for them to be able to step in and make those decisions. So we do recommend that you select one person and don't make authorities. And yes, I fully understand that sometimes that can make it difficult for family members. They're like, "Well, why do you trust them?" I mean, I joke with my family. I'm the person on my mom's will. I'm like, "Well, clearly," I'd say to my brothers, "I'm mom's favorite." But my mom would tell them, and she'd be like, "No, just ignore Jesse. That's not what it is. Jesse's the lawyer." So she's the one who knows what to do in the event of my death. She's like, let her take care of it because it's going to be easy for her, right? So while I can say I'm the favorite, in reality, the reason why my mom made me the executor is because I am a lawyer, and you don't have to be a lawyer. I'm not saying you have to do that, but I'm the one that has the personality to be able to handle the work that needs to kind of get handled after that. And so just kind of think about that. Discuss it with the person. Make sure that they're not caught by surprise. Some people don't want the responsibility. They don't want to be making the decisions. And so be sure you talk with them, explain why you've chosen them, explain some of the decisions that you would make, especially what you wrote in the will to clarify what you mean by things, or, medical decisions, what you would do in the event when you're not able to answer, to be able to make decisions for yourself. So that way you empower them and give them the ability to understand what you are asking them to do, and then for them to ask you questions, because when you're no longer available, then they're kind of like, "Oh, I don't know what to do." Just as important, in my opinion, is to have conversations with the people you don't select. As I'm joking with my family, right? My mom did have that conversation with my brothers. But I'm the youngest, right? And my oldest brother was like, "Well, I'm the oldest. Why am I not the one doing it?" And it's like, so sometimes, like, right, you want to explain to the people who weren't selected, who think they would be, like my older brother. And so that way they don't feel hurt or like, "What, did mom really not trust me to do this work? And did she not think I could handle it?" Right? Don't leave it unspoken, because you're not going to be able to answer the question for them. And then now it's just something that's always going to be lingering in their head. I'm like, "Well, am I not trusted? Does she didn't feel like I could do it?" Like, so have those conversations with the people that you also don't choose. And then, of course, when you have an alternate, have the same conversations with the alternate. Sometimes there's a way to kind of do things where you're like, "No, they're both equally. I got two kids. They're both equally able to do this. All my people are Bob and Susie. Bob and Susie, I trust them both." Well, then maybe consider making one person and one the other person, right? Make Bob the agent for for this durable power of attorney, which we'll talk about, and then one for your medical power of attorney. Make Susie your medical power of attorney. So, right, like there's some things that you can do there if you want. But I think that, like, the further you kind of get into um like questions about who really what makes sense, talk with the lawyer. If you're going to be working with a lawyer, talk to the lawyer about the choices. Okay. All right, now let's talk about planning for death. Key takeaway number 2, everyone needs a will. Regardless of what I say after this slide, everyone needs a will. It's better to have a will and not need it than to need a will and not have it. So the probate process in Texas is actually pretty straightforward, pretty easy to get through. Um, but it requires a well-drafted, properly executed will, which is what we're going to be talking about today and what the will is. And then in my other session on how to draft their own documents, I'll talk about that as well, right? When you have a well-drafted, properly executed will, the probate process can be very straightforward and not as complicated as a lot of people think it will be. The reason why people talk about complex probate in other states, because in other states it is complicated. It is difficult to do. Texas, we've streamlined a lot of that. And in fact, going through the probate process may in fact be less expensive than trying to do some of these other alternatives that other states have to do. But because someone at a national level has kind of said, "Hey," or as Ms. Nia says, the street committee, someone's like, "No, you have to do it this way. This is how you avoid the expense of probate." Well, in Texas, the well-drafted will actually, again, could be less expensive than this other alternative that they're talking about. And so, So don't have like all these things, because all of that other stuff we're going to talk about. We're going to talk about probate alternatives. We're going to talk about how to avoid probate. We're going to talk about that right now. But regardless of what I say, you still want to have a will, because things can happen. And I'm going to talk about that in a bit as I kind of talk through the different things. You're going to see why having a will really matters. All right. Things you need to understand about wills is property and what happens to. So most of the time, what we're dealing with after a person passes away is property. There's also going to be some financial issues, matters to be dealt with, but a lot of the time we're talking about what happens with the property that we own at the time of our death. Sometimes I get questions. I'll get, I don't need a will because I don't own anything. That is not true. Everyone owns personal property. You have your clothing, your furniture, your jewelry. Has some examples. Your car. A car is also personal property. So everyone owns something. Do not underestimate the value of personal property to loved ones. Sentimental items are not sentimental for long, like for they're sentimental for various different reasons, right? Um, I have things from my great aunt who was a crafter, and I cherish the dolls that she made for me when I was a child, right? There's no financial value to that. If I was to have a garage sale, I'll be, someone might buy it for a quarter. But it's huge sentimental value to me. So, right. So there are people who they're going to have sentimental value to items. It's like, oh, I always think when I think about grandpa, I always think about him in his sweater, and I really would love to have his sweater. Grandma made the best quilt. I really want to have one of her quilts, right? Those are things that have actual great sentimental value to people. But so there's that. But also, what happens to your personal property? What's going to happen to it? So you're living somewhere. Right? You're living somewhere. You're living in an apartment or maybe a residential facility, or your roommate, like, right? You're living somewhere. What's going to happen to that? What's going to happen to the property? Is it going to get donated? Is there going to be an estate sale? If there is an estate sale, who's going to get the money? Who's going to be responsible for having the estate sale? If you're renting, who's going to have the authority to walk into that apartment and get the stuff out? Landlords don't just let anybody in. And so it's like, so someone is still going to have to deal with your personal property that remains, either dealing with the sentimental property and also kind of dealing with what to do with the rest of it. Maybe it is a donation to your favorite nonprofit. Or maybe it is, oh no, let's have an estate sale, or I just don't care, but still someone's going to have to be able to do something for that. And by having the will, that actually makes it easier for them to do that. They might not need to go into probate court depending on what personal property is owned, but the will itself provides the authority for the person to be able to walk into the apartment and deal with the stuff. And in some cases, if there is a need to go into probate court, then you have it. Someone must have the authority to do that property. So I already kind of talked about that, right? For your personal property, but the same goes for your real property, your house and your land. Like, who's going to be responsible for that? So someone needs to have the instructions on what to do with it and then how to kind of handle it. The other thing is that title property, that's your car, your houses, land, RVs, have to go through some type of a legal process to clearly transfer title to that property. So think about that, right? It makes sense. When you buy a house, you have a deed, right? And the deed says who sold the house or who it was the person who passed, and it says who currently owns the property. So, right, with a car, you have a title from a car that says you own it. And then when you sell it, you got to sign that title over to the other person. So that way there's proof that they own the car, right? So it makes sense that after a person passes away, that something has to happen for those property that has that documentation, the deed, the title, to show who's the next person that owns that property, right? And so that requires the legal process. It requires some kind of step to transfer that ownership. And so that can be done versus a will. We're going to talk about some other documents that you can do that. But again, the will with the executor is going to be able to give them the person the authority to be able to do that. Is it selling the house? And then if it's selling the house, who's going to get the proceeds? Who's going to be responsible for deciding whether or not to make repairs to the home, sell it as is? Who's going to accept the offer? Right? So that's where it comes into play, where having an executor and having a good will make a huge difference in making this process more smooth. Verbal agreements are not enforceable in the state of Texas, especially as it relates to land, and houses. So I get oh, we have an agreement. Great. Put it in writing. Because just because you have an agreement doesn't mean that the other person also has the same agreement, right? I mean, we talk about like, in the lawyer world, it's like the meeting of the minds. Like, do we understand? Well, sometimes a person might be like, oh yeah, yeah, we agree, and then the other person, when you ask them like what they thought you agreed to, it's completely different. So put it in writing, make it clear, so that way if there is questions about what that agreement was, it's now in writing, it's now enforceable, and then if there's a need be for someone to come in and intervene, you have the documentation in place to be able to handle that. Another misconception, which is not an incorrect misconception, but it's not an accurate perception, which is that property automatically gets passed to the other co-owner when a person passes away. So when you own property together, the other person is going to get it automatically when the person passes. This is a misconception, particularly as it relates to community property. That is not the case. The default in the state of Texas is that when people own property together, they each own what is called an undivided interest in the property. So they have a right to the full property use, but they own a portion of that property. So that is what is the default in Texas. That is the case with community property. So when couples buy a house together and they're married, right, that they have purchased that home as community property. It is still the default. Each spouse owns 50% of that property. The surviving spouse does not automatically get the other half. It depends. Remember, individual plan, individual situation. So if you are married and all of your children are the children of your spouse, then yeah, without a will, the law says that the property goes to your surviving spouse. That's true. That's accurate. Again, you still want a will because the probate process is more difficult without the will. So that's true. Um, I should let me just kind of go through that, right? So like when you go through a probate process and and then you're doing from the court of law, well, how do we know? How do we know that the children are the only children, right? So sometimes the court may decide to appoint somebody to go verify that, to verify that there is only that there's no other children born from a previous relationship that may not be known, right? And so that can cause some delays and some difficulties. And so a will would make that clear, would remove that problem altogether. But when we're talking about like the automatic ownership, if you have children from a previous relationship, that property does not, that 50% does not go to your spouse. That 50% now goes to all of your children equally, including the children from a previous marriage. And so while you may think that it's going to, because your community property, that it's going to go to your spouse because you bought it together, that is not the case. So again, kind of a misconception that people have because sometimes it works out, but sometimes it doesn't work out the way that they think it's going to work out. And so I say, why leave it to the courts, right? It's your property. You worked for it. You've earned it. You want to make sure it goes to the people that you want to have it for. And the only way that you can guarantee that it's going to work the way that you wanted to do it is to write it, is to put it into a binding will. And so, so why leave it up to the courts? Why leave it up to the law to figure it out? The law lets you decide, so you should decide. All right, so now I've kind of told you why you needed a will and all the different misconceptions around that. So what is a will? A will is a legal document in which a person called the testator, that's just legal language, that's what you're called, writes down what they want to happen to their property, the things that they currently own, and their debt, what you owe, right? Final bills, called the estate. That's the estate together. After their death and who they want to manage that estate, known as the executor. So that's the executor. That's the person, the representative. That's what you're going to be naming. Um, the will also cover the care of minor children or children, adults living with disabilities under our care. The will can also incorporate that, but it doesn't always. It doesn't have to, but it can incorporate that. Most of the time, for a lot of people, the will is very much focused on property and debt. Children are included in that, but typically it's focused on the property. A will covers probate assets only. So what does this mean? It means that there are two types of property that happen after a person passes away: probate assets and non-probate assets. Non-probate assets are property that are owned in such a way that ownership transfers to a specific person without going through the probate process. That's just basically what it is. Our folks in Austin and our folks in DC, mostly in Austin, have said, hey, when you own property in this way, it doesn't have to go through the probate process. It may end up going through the probate process, but it doesn't have to. And so for a lot of people, what we're talking about is financial accounts. So retirement accounts, IRAs, 401ks, they're going to designate a beneficiary. Life insurance proceeds, designated beneficiary, and then payable on death accounts, beneficiary. All right, so let's talk about each of these a little bit more. So retirement accounts, pretty straightforward. 401ks, retirement plans, everyone kind of knows that. Life insurance proceeds, when you have a life insurance policy, you're going to want to name a beneficiary on that, right? You're going to go through and 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 name them. What's the effect of being a beneficiary for these accounts? You contact the financial institution at the time of the person's passing. That financial institution will say, so sorry for your loss. This is what we need from you. Typically, it's a certified copy of the death certificate and some type of a form that needs to get completed by that the financial institution. It's their own form that they're going to ask you to complete, and you're going to submit that, and then they're going to disperse the money in those accounts according to the terms, according to who is named as the beneficiary. So that's basically what happens in these situations. Um, what happens when you don't have a beneficiary? This is where we get into the good to have a will. All right, if you don't have a beneficiary listed, then it's going to belong to the estate. That's who's going to be, um, that's how the property will get passed. So if you have a life insurance policy and you don't have a beneficiary listed, that financial institution is going to write the proceeds of that benefit to the estate, and then it's going to get handled in the probate process. And that's how this type of property becomes a probate asset and why a will matters. So let's go through this life estate scenario, okay? I mean, a life insurance scenario. You have a life insurance policy for $10,000. When you name a beneficiary, they're going to contact life insurance company and said, okay, so sorry for your loss. Thank you for the paperwork. A check is written to the name of the beneficiary for $10,000. That's what happens. When a person passes and there's no beneficiary listed, insurance companies can say, okay, this has to go to the estate of the person who passed. Now we're going to look at the will. Okay. So when we have a will that says that the entire proceeds are going to go to Bob and Susie. All right. Well, you gotta go when you go to probate court, you have to have an attorney, right? And so we have a will that says it's going to go to Bob and Susie. So the attorney gets hired. Let's say the attorney costs $1,000 to do all of the work that needs to be done. And then once the probate process is complete, now Bob and Susie are going to get a check for $4,500 each, as opposed to $5,000 each, right? That right? We got to pay the lawyer first, and so now, and that comes out of the life insurance proceeds. And now we have the kids splitting the money, what's remains splitting. What happens if there's no will? Oh, now we got to figure out who is the heirs, right? Well, we got Bob and Susie, but is it only Bob and Susie? We're not sure if it's only Bob and Susie. A person has passed, there's no spouse. We just have Bob and Susie, our kids. We're like, yep, it's just us. Well, we don't. Do you know everything about your parent? Not necessarily, right? So the court may say, yeah, I don't know. Let's go make sure there's no other kids from a previous relationship that you don't know about. And so now that court is going to appoint an ad litem, an attorney ad litem to go research, just confirm that there's no other attorney, right? And so now you have the lawyer that you hire, $1,000. And now the court has said that you need to hire an attorney ad litem because the estate's responsible for paying those fees. And that attorney ad litem decides to charge you $2,000 for, when they're all done, it's about $2,000 worth of work. So now, instead of the $10,000 that would have happened if a beneficiary was listed, now it's $9,000 when there is a will. Now we're looking at $7,000. So now each of them, Bob and Susie, are going to get $3,500 each, right? And so hoping that kind of shows why you need a will, right? Because it makes it so much easier, right? Now, why do you have, you're like, well, Jesse, if I put the beneficiary on the life insurance process, why do I need a will? Because sometimes there's surprise life insurance policies. Believe it or not, I have had more than one case in my career of doing this where people have come and they have discovered a life insurance policy that a former employer had provided. that that was part of their benefit and they just never listed a beneficiary on there. Right? Like so that happens, so sometimes things happen where you're not, and this is just an example, right? Like this is just an example of what happens when you do that because sometimes things do just kind of show up and you're not aware of it. And so, um, but that is something that happens. All right. Payable on death accounts, you're going to want to do a beneficiary designation on that as well. But I want to talk a little bit about what these are your bank accounts. These are your savings accounts and your checking accounts that you have at your your bank or your credit union. You're going to want to be able to put those into payable on death accounts. So what are we talking about that? For most people, most households, there are three things that are kind of, well, four, but there are three things that really are the issue during a probate process. One is the house, if they own a house, their car, their personal property, which we talked about, but it's your banking accounts. Banking accounts is the one that usually triggers a probate proceeding more than anything else. I have had so many clients, so many people who have come to me needing to do a simple probate process, which is not always simple because there's no will, if there's no will, right? Who need to go through a probate process to get access to only the bank account. And that is it. And so when we're thinking about those things, and I'm going to talk about houses and car in a minute, but like when we're talking about the bank account and that being one of the reasons why you need to go into a probate, you can solve that by doing a designation on a beneficiary, a payable on death account. They don't own the account. They are a beneficiary. So they are not a co-owner in the account. They only have access to the funds once a person passes away. Another reason why that's important is that it will help with getting access to the funds to make final payment or to make final payments for things. The estate is responsible for paying final debt as well as funeral expenses. The estate's responsible for that. And so having access to that checking account so that you can pay the mortgage and the bills while you're going through the process of transferring title and dealing with all of that is really important. Even if you are going to go through a probate process, having access to the funds helps because who knows how long it's going to take you to start that probate process. Average is 4 months after a person passes. Um, so they can continue to make those payments and things along that lines and pay for the funeral. So you want them to have access to that account. And also, if it's the only thing that needs to go through probate, we've now avoided the probate process because there's a payable on death account. You can, if you wish, you can make a co-owner on the account. I always say be aware of that, right? When you create a co-owner on the account, they own that account just as much as you do, right? So they can go in, they can take money out, they can put money right, they can write checks on that. It really is, you have to be sure that you're putting people that you trust that are not going to do anything with the funding. As a lawyer, I usually just say, hey, do a payable on death account, but you just don't know. I am a co-owner on my mom's bank account because I help her pay her bills. And so but that's it. Like, right. It's kind of one of those like do what works in your own situation. But that's the way that you would be planning on what to do with your bank account. It's either make it a payable on death account or make a co-owner on the account. Um, Oop. um, So just kind of be aware of that. So the last category for a non-probate asset is a joint tenancy with a right of survivorship. Remember what I talked about when owning the property? When you own property, the default is undivided shared percentages, right? If two people own the house, 50%, that half goes according to the will or according to the laws of without a will, that's how it passes. You can create property as a joint tenancy with a right of survivorship. That can be your real property, your car, your bank accounts. You can do that. And what happens there is that it's now a written agreement that says that on the passing of the one, the person who survives will now own the property, right? They will inherit the property. I always say be really careful about that because it's very easy to put it into one, very hard to undo it. Because you can have a lot of the same results in a will, like you can do a lot of the same things in a will that doesn't have the same permanent impact as creating a joint tenancy with a right of survivorship. And so I do highly recommend if you're thinking about converting property into a joint tenancy with a right of survivorship that you speak to an attorney about it to just be sure that it fits your plan and that it's not going to be something that you can't undo later on down the line if it turns out that you change your mind. That's it. Those are the things that are considered non-probate. Everything else is considered a probate asset and will be governed by the will in the court process, assuming that we go to court. So key takeaway, I already talked a lot about this, is the access to the bank account and beneficiaries are named. And so because we want people to get access to the bank account, I already covered a lot of that. Right. So now we're going to talk about the types of wills, just so that you understand what it is. The key to everything is to have a well-drafted, properly executed will. That's the key part of it. They don't have to be super complex wills. When you go to a lawyer and they draft a will, there's a lot of stuff in there because we're trying to make sure that we cover all of the potential bad news. Right? Bad news, Jesse. We're trying to make sure we're going to stop problems before they happen. But you don't have to have a full complicated will. It just has to serve all of the functions of a well-drafted will. So the first type of will that we're going to talk about is a holographic will. That is basically legal language of a will that is 100% in your own handwriting. Okay, that is signed and dated. So you're going to take out a piece of paper, you're going to take out your handy dandy blue pen, is what I recommend, and then you're going to write, I, Jesse Campbell, being of sound mind, write this is my last will. I leave everything to my dog, Peggy, and in trust by my brother Bob, right? Like, um, and you know, that's a will, right? So it's not a good will, but it's a will. And then you sign and date it. So 100% in your own handwriting. So that is the first type of will. For a lot of people, not a lot of people, for some people, if this is all you can do to get a will in place, do it. It's better to have a will, a bad, not badly, don't write a bad will. It's better to have a will, right, than no will. So even if this is if this is the only option, do it. In order for this to work, just to let you know, so when you write a will, that's it, by the way, it's just in your handwriting. You cannot dictate. You cannot be sitting someplace and ask someone else to write it in their own handwriting. So it has to be in your own handwriting. So when you go to court and you admit the will to the court, so this is what happens. Your Honor, I'm here admitting the will. It's a handwritten will. So what is the judge going to ask for? The judge is going to say, okay, I need two witnesses to come and testify to the handwriting of the will, right? That there's someone who is disinterested, which means they're not going to inherit in the will. They're not related. They don't owe the estate money, like completely disinterested. They have to be able to come in and testify to the handwriting of the will. I don't know about you, but that's getting harder and harder to do. A lot of people don't write a lot of things by hand. I actually recently went through this where it was like, is there where we had to look for someone who had handwriting knowledge, and it was things like, well, can you testify to that? And it's like, can you and they're like, no, I don't, maybe a Christmas card, right? Like kind of like it's like I don't think I've ever seen their handwriting in something. It can be very difficult to find people who can testify to the handwriting who is not interested, right? Who's not related to the person. And so that is what the concern is. So what are the options that you can do to be able to emit a holographic will, a handwritten will, without looking for people who understand the handwriting? You can do this by adding witnesses. So you can write your will, and then when you sign and date it, right, it's going to be handwritten. And then, right, your two witnesses, we do recommend two, disinterested, again, people who don't gain or anything like that. So maybe your neighbor, friend, coworker, someone to come and do that. You're going to sign and date it while they're watching, and then they're going to sign and date it as witnesses. And then what happens at that stage is that you're going to court, Your Honor, here's a handwritten will. Court's going to say, okay, I need one of those witnesses to come to testify that they were there, they saw the person say that it was their will, that they had written it, and they saw them sign it, and this is intended to be their will. And so then you have one witness who is available to come and do that. So that is why it's beneficial to have a witness. And that's the process. All right. So that's what it takes to have a handwritten will and for it to be admissible into court. The second type of will is an attested will. And what is that? Is a typed will that is signed and dated. This you can dictate. Someone can sit there. You can say, this is what I want you to write for my will. Someone can then type it up and they're going to print it. All right. And so it's 100% typed. There are requirements. So with the handwritten will, it just has to be 100% your own handwriting, signed and dated. That's it. That's the only requirement. But with a testated typed will, you must have two credible witnesses over the age of 14 sign and witness that will. There's no a will that is only signed is not that's typed and signed only with no witnesses is not a valid will. It's not a properly executed will. So you need these two witnesses. Again, that same process has when you have witnesses for handwritten wills. Like, Your Honor, I have a typed will. All right, I need one of those witnesses to come to court and testify that yes, I was there. They said it was their will. I watched him. He was of sound mind. They were over the age of 18, and so this was a properly executed will. And so that's what makes an attested will. So now you're going to say, hey, Jesse, what happens if there's no witnesses available? Well, then the highly recommended next step is to include what is called a self-proving affidavit. So I get a lot of questions like, isn't a notary required? No, a notary is not required. For a handwritten will, it just has to be 100% in your own handwriting, signed and dated. For a typed will, it has to have the two witnesses sign and date it at the same time that you sign and date the will. That's what's required for a valid will in the state of Texas. The notary part comes in the self-proving affidavit. So this is an affidavit that's included with the will, that says that it's signed by you, the testator, the two witnesses, and a notary all at the same time, right? So you're signing and dating your will, your witnesses have signed and dated the will, the notary has watched all of this, and then they're going to sign and date self-proving affidavit. The testator, you, the person who wrote it, your witnesses, and your notary. And so then what happens is that when you go to court, Your Honor, this is a self-proved will. There's a will that got executed with a notary. Here's the affidavit that says that's in compliance. And the judge is going to say, okay, the will has been admitted. So when you can, the best thing you can do is to have a self-proved will. Sometimes it's difficult to find a notary willing to do that if you write your own will. Not all notaries will sign a will. That does require some specific steps for the notary. And so, like, you're not going to be able to go to UPS store and get. I have yet to find someone who says that they were successfully able to execute a will at a UPS store. Sometimes your bank will do it for you. Some banks will have a notary to do that. Obviously, you would want to call your notaries and make sure. But as part of the partnership and the work that we do with Amos, NRCDC does also assist with notarizing wills. So just be aware of that if you decide to write your own will. But so just kind of when you're going through. So now, what does this mean about fill in the blank wills? This one is the law is very clear. There's a fill in the blank will is not valid in the state of Texas. It's 100% in your own handwriting, signed and dated, or it's 100% typed, signed and dated with two witnesses. That the law is very clear on that. So do not just go Google a will and just print it out and then write it in. There is the Supreme Court fill in the blank wills. Now, when we talk about drafting your own wills, that's something I talk about in our part 2 of this, which is how to use the Supreme Court fill in the blank wills for your own estate planning purposes. And so they're pro se. Pro se means you're doing it for yourself without an attorney. So what about those? It does say that you can print it and fill in the blank via hand. I recommend that when you do that, since you are going to be on the computer, just fill the will on your computer, printed where it's 100% typed, and then use the two witnesses and your self-proving affidavit was all in that will, and do that. That is what I highly recommend because they are currently mismatched. And I don't have any good information that I feel confident that I'm like, yes, go ahead and do everything and fill in the blank. Even though it says that, it will likely be admitted. But if you were to ask me, I would say fill in the blank on your computer and print it out with everything typed on the will. So, because the law is very clear, either 100% written or 100% typed. All right, so that's the will. That the will, if you want to know what needs to go into the will, the portions of it, what makes it well drafted, please come to part 2 where we will go through each of the parts, and so that way you will know what to write. We will use those Supreme Court forms as an example on using those, but it can also serve as a template. So even though that form may not be exactly what you need, it can still work as a template for when you're drafting your own documents. So come to that one where we will talk about what makes a will a well drafted will. Okay. So transfer on death documents. Lots of conversations about this. You may or may not have heard about this, but these are documents that you can prepare that transfers property without going through the probate process. So, all right, let's go back. Non-probate assets automatically, the way that they're set up, they automatically pass outside the probate process as long as the beneficiary is listed, right? Your life insurance, your retirement accounts, your bank accounts, and then of course if you have property, it's joint tenant with a right of survivorship. But those you're going to name a beneficiary, and then they're going to pass outside the probate process. They only become part of the probate process if there's no beneficiary listed. That's the non-probate. Well, what remains is your house and your car. Those are titled properties, right? There's a deed and a car title. And so we need to do something to transfer the ownership of that property. So you can do a transfer on death document to pass the property without going through the probate process. If you don't have a transfer on death document for your house or your car, it will pass in the probate court because it's still a probate asset. That's how it will get handled. But that's kind of the distinctions between that. Some people may feel like it's not really a distinction, but they are, right? It's having the documents in place and then and things written the way they need to be. For your house and your land, that is a transfer on death deed. You have a deed when you got your house and land. And so to transfer it on death, you are going to do a transfer on death deed. For vehicles, it is a beneficiary designation of a motor vehicle. Okay. Now, sadly, I did not update this yet, but there is a new law that went into effect that there is now a transfer on document for a mobile home. So that is categorized as personal property. There was always kind of like this gap that we weren't sure what document to use for your mobile home. And so now it's clear. So for a house and your land, that's going to be a transfer on death deed. For your car, it's a beneficiary designation of motor vehicle. A mobile home classified as real property is going to be transferred under a transfer on death deed. But a mobile home classified as personal property, you're going to do a transfer on ownership. No, I'm sorry, an ownership statement document. So I don't have it on the slide. Sorry about that. But if you were to do transfer on death mobile home, if you're comfortable getting on the computer and Googling it, you are now able to do that for your mobile home as well. And if you own the land that it sits on, then you would do a transfer on death deed for your land. And so what this means is that you still own the property. You can do whatever you want with it. You can sell it, you can mortgage it, renovate it. You got to pay your property taxes, like all the stuff. It's still yours, but when a person passes, there will be a recording of the death, and then that will be sufficient to show that the person named in the transfer on death document is going to be the person who owns the property. Transfer on death deed, you're going to prepare it, you're going to file it in the county where the land is recorded, then they will stamp it and they'll send you back. You're going to put that in with your will and all your other important papers. For the car, as well as the mobile home, you're going to file the documents with either the tax assessor collector, which is for your vehicles. Then they will send you a new title with the beneficiary designation on that. You're going to put that in your safe place. And same thing with this ownership statement for the mobile home beneficiary designation. It's going to get filed with the State Department. I don't remember off the top of my head, sorry. And then you're going to get the new statement of ownership that you're going to keep with your paperwork. And so that is so that's the transfer on death document. Of what's really, really important to know about this is that this takes priority over a will. Why? Because it's not going to show up in the court. When you have a transfer on death document, you've already transferred the property, which means that it's effective upon death, which means it's no longer a property subject to probate. So if you are going to change your mind, you must revoke the old transfer on death document. Otherwise, it's going to go to whoever it is, right? So, and it doesn't matter what the timeline is. You write a will giving the house to Bob, and then you do a transfer on death deed to the house to Susie. Afterwards, transfer on death deed controls. Susie's getting the house. You give the house to Susie and transfer on death deed in 2024, and in 2025 you decide, nope, I want to give it to Bob. I write in a will that the house goes to Bob. Susie owns the house. It does not matter when in the timing of anything. It does not matter if there's been a will that revokes anything. Like, if you're going to change your mind, you must either file a new transfer on death document or you need to file a revocation. Very important to think about that as you do that. Transfer or beware. So I say, this is not always the best option for everybody. Sometimes there are things that you want to do that doing a transfer on death document is not the way to go. I understand the desire to make things easy and to make things to save money. Like I get that. But sometimes trying to do avoiding the cost of something can actually create a bigger problem that you were trying to solve to begin with. So remember, we're talking about individual planning and thinking about it in that way. So a transfer on death document, generally, I do recommend that it goes to a single person. That is what I would prefer. It's not always the case. You can have more than one person, but the one that ensures that there's not going to be a problem is when there's one beneficiary. Because let's talk about conflicts. You have two beneficiaries inheriting the property. They will inherit it equally. So Bob and Susie are going to get their house equally. I have Bob and Susie getting my home, right? Now, I am relying that they like each other, that they get along, and that they will agree to who's going to either live in the house or if they're going to sell the house. They're going to be able to coordinate all of that. But what happens if you don't know that? You know they're going to sell the house. You want them to sell the house. That's the plan to sell the house. But they don't always get along. Maybe one of them does want to move in, right? Then it's better to actually put it underneath a will because then the executor will actually have the final kind of decision-making power as opposed to Bob and Susie trying to figure it out for themselves when there's a conflict on that. It's also not a good situation when there's going to be instructions. So what are the types of instructions that I have seen? Life estate. They want someone to have a life estate in the property. Better to make that clear so they can live life estates. They can live in the property until they're passing, and then it's going to get inherited by somebody else. Like someone else is going to own it. That should go into a will, in my opinion, right? Because it's easier to control and make sure that the language is written in such a way. Other things, Susie helped me fix my roof about 5 years ago, and she paid for that. I want her to get her money back, right? So I want Susie to get the first $10,000 of selling the home, and then the rest of it is split between Bob and Susie. Well, you can't do that in transfer on death deed. You cannot put instructions like that into a transfer on death deed. All you are doing in that is saying who owns the property. They have to recognize that there was this agreement. And remember, verbal agreements are not enforceable. Remember, if it's a transfer on death document, it's not going to end up in the probate court for the executor to make decisions. So kind of think about that. Many people are able to do a transfer on death document. Like all of these are like buyer beware, lawyers thinking of bad case scenarios, right? I'm like, let's try to stop a problem before it happens. But again, it's an individual plan. You know your family better than I do. And if you think that that's going to be fine, then you can obviously have multiple beneficiaries. I'm just kind of letting you know, think about it because it's not going to be ideal in all situations. But it's a very effective way to avoid the probate process. And so let's kind of repeat that, right? Four major things that people have: personal property. You're going to have a will that's going to basically say what's going to happen to your personal property. Everyone's going to either have the estate sale, donated, whatever, right? You're going to have your bank accounts. You're going to have a payable on death account for your bank, right? And so now the beneficiaries are going to get access to that. Then your house, the third thing that most people have, is going to be a transfer on death document. Person passes, you're going to make sure that the recording of the death is with the county clerk, and that's going to be that. And then with the designation for your car, you're going to have the designation beneficiary, or your mobile home, you're going to have the ownership statement. And then that is going to be the new title is going to be signed and it's going to be accepted. And then that's going to be the showing of the ownership. And for many, many people, that's it. They don't have to do anything else. And that going into probate will be if something shows up. A life insurance policy we didn't know about, an inheritance we didn't know about that we got because we're the heir, right? So the things that are unexpected, then that will go into probate court if it's necessary. It might not be. So those are kind of the ways to avoid probate. But again, don't fear it. If the best thing to do is to go through probate, then do that. Because sometimes it can be much more expensive, much more complicated to trying to avoid the probate process when probate would actually help. Trust. We're not going to spend a lot of time talking about trust because it's complicated. Like it can mean a lot. But I get asked about trust because national experts will talk about needing trust. Oh my goodness. I just saw it again recently being like, a personality saying, oh, here's this TikTok that's going really viral because they're talking about, you never write a will. You want to put everything into a trust. And it's like, where does that person live? Because I guarantee it's not Texas. Because again, just as a reminder, we're talking about Texas and what happens in Texas. There are states where the probate process is very complicated, is very difficult, and the way to avoid probate is through a trust. For them, trust is their estate planning, is their advanced planning. In Texas, that's not necessarily the case, right? In Texas, when we're talking about what people mostly have, what most people have, bank accounts, a house, a car, and personal property, um, a trust isn't necessarily what you need. It could very well be that you just need a transfer on death instrument for everything you own, designation of beneficiary, and then your will with the instructions on what to do with the personal property. And, that's it. You might not even have to go into probate court, and creating a trust just creates more complications on that may or may not be needed. Now, that being said, you may need a trust. So a trust is an arrangement where one person or entity called a trustee holds legal title to property for another person called a beneficiary. I always say, and there's many different types. There's living, revocable, special needs, things like that. If you believe that you need a trust, then you should talk to an attorney about it. Um, but there are needs. There are reasons why a person would need a trust. For some people, it's tax planning. For some, it's they have children that would be inheriting the property that they need to be worried about that special needs, right? Like they aren't able to manage the property on their own, or they're too young to manage the property until they're of an age and to be held in trust. And so there, trust can be created to become eligible for benefits, some government benefits. And so a trust may need to be created for that purposes. So there's a lot of different reasons why a trust may be needed. But if the only reason why you're thinking about doing a trust is to avoid probate, that may not be a good enough reason because the expense is still there. You're not avoiding an expense. The work that's needed to be done to transfer property into a trust is the same work that needs to be done during a probate process to transfer the property to the beneficiaries, writing deeds, paying off debts, things along that lines, right? And it actually may cost you more to do a trust, where all you're going to do at the end of the trust is disperse the property, upon the passing of the person. So I'm not saying don't do it, just be cognizant of why you're doing the trust, and talk to an attorney about it. So unfortunately, I do have some bad news, which is debt survives. I don't know why. I do know why. There is a misconception that debt gets written off when a person passes away, and that's not always the case. When an estate is insolvent, basically it's bankrupt and doesn't have any assets, a lot of creditors will write off the debt, and not attempt to get the estate to pay the debt. But it does actually survive, and so if the estate does have assets, they have to pay the debt, and so don't assume that it just goes away. But for some people, it will. For some estates, the debt does go away and it get discharged. But oh, by the way, it doesn't mean that there's not going to still be situations involving that. Because cancellation of debt is considered income, and if the creditor issues a cancellation of debt income form, a 1099-C, I believe, then the estate has to file a tax return and pay taxes on that income. So just it doesn't mean it necessarily goes away. There's always something that has to, which is why I talk about the thing that has to happen is go talk to an attorney. So that way they can sit down and see what's going on and then help advise how to move forward with any debt that exists, because maybe there is a way to negotiate a discharge or a reduced payment amount or something on that lines for the for that type of debt. Now this is unsecured debt. What I just talked about was unsecured debt. That includes credit cards, medical bills, things like that, right? That's what I was just talking about. However, real property and cars is inherited subject to the loan, right? So a house is inherited subject to the mortgage, a car is inherited to the car loan. If you don't pay those, what happens? They come and take it away, right? So if there's a mortgage on the property, if you don't want the house to be foreclosed, that person inheriting the property needs to pay the mortgage. If same thing with the car. Lots of different things that you can do to plan for this, right? So it's gonna be mortgage lien, anything that's secured, right? There's something that says, hey, we will own this property if you don't pay. That's basically what we're talking about, secured debt. There's lots of things you can do to plan for that, right? You can do a transfer on death deed and then have the life insurance policy be the proceeds go to the person who's getting the house under the Todd, and then and let them know it's like, hey, I'm making you the beneficiary of the life insurance policy, and the purpose is for you to pay off the mortgage that still exists on this property, right? It could be that there isn't a way to pay off the mortgage. There's nothing in the estate to be able to pay off the mortgage, and then it's like, sorry, Bob, you're gonna have to pay the mortgage, right? And Bob's like, all right, I guess I'm going to inherit the house subject to the mortgage. I got to figure out how to pay it, or I need to sell the house and, to be able to do that. The key thing to keep in mind on all of this is a reverse mortgage. When it comes to mortgages and liens, we have found, not 100%, depends on who you're dealing with, like anything else, but a lot of times the mortgage company is willing to work with the executor as long as the mortgage is getting paid, access to the bank account, right? As long as the mortgage is getting paid, they're willing to wait, appropriate some amount of time to allow the benefit to either sell the property or the beneficiary to acquire their own financing to assume the loan or whatever, right? So typically that will happen. A reverse mortgage does not work the same way. In a reverse mortgage, you have 6 months from the date of death to pay it. That's when it's due. So, as I kind of spoke very quickly, the average length of time to start a probate process in Texas has been hovering around 4 months. That means that executor and beneficiary will have 2 months to figure out what to do with that reverse mortgage. So it's really important to let people know that there's a reverse mortgage on the property. There's other techniques that you can do, which is one, start the probate process as quickly as possible, or pass the property according to a transfer on deed so that it's effective immediately to give the full amount of time necessary for the beneficiary to either find financing to pay off the mortgage or to sell the house, like whatever it is that they're going to do without the house being foreclosed. So that's a distinction. Mortgage companies, you have a little bit of time. They're not going to let you be indefinite, but like you have some time. Reverse mortgages, you have only the 6 months to be able to do that, and they need to be aware that there is a reverse mortgage and they only have 6 months to be able to do that. It can be very, very stressful for the beneficiaries, especially if they're living in the home, to find out that there's a reverse mortgage and they're unable to pay it. Right? That's pretty much it in terms of property planning for when a person passes. Um, so the last thing that you would do in preparing for death is a disposition of remains. This is just a legal document that's going to name an agent. That's what that called. Who's going to make the decisions with respect to disposition of remains? This is basically funeral arrangements. You're naming who's going to be responsible for handling your funeral. The document can also include instructions on what you would like to happen. If there is burial or cremation instructions, there's a prepaid plot that, the various things that people have. This is also the document that we would include those instructions to your agent to be able to do that. It's a pretty simple document, does not require too much for planning for it. All right, that's it. We're done talking about planning for death. Now we're going to spend the rest of the time talking about planning for incapacity. Um, it's also going to go pretty quick because they're actually not that complicated because unlike the will, a lot of the capacity documents are either forms that the folks in Austin had written it for us. We know exactly what it has to say, so you don't have to think about it. The template that we send you is the template you can use, or they're really pretty straightforward, simple documents to use. So that's the good news. The hard part's done. Is what I guess I'm saying. So the first thing is called the Supported Decision-Making Agreement. Not everyone's going to need this, but it's a really useful document for two different situations. So what is it? It's an agreement in which an adult, the person signing it, is requesting a supporter to help with decision making. The supporter does not make the decisions. The supporter is there to help. And so basically it would be things along the lines of like, oh, I'm thinking about buying a house. I don't really understand the mortgage situation. So the supporter shows up and then helps with making the decision, right? Um, and or someone's like, hey, I got this. I'm going to the bank and I really want to transfer money to another country to this person. The bank is going to call the supporter and be like, hey, person's trying to transfer some money. Did you want to come by and talk with them before we do this, right? It's prevent that financial abuse that might happen. So it's a real useful document for people in two situations. One, when children are aging up, they're living with a disability, they are able to make decisions on their own, but they need some support. So as they turn 18, that's really useful. It's also very useful for those of us as we age. Unfortunately, for some of us, there will be a cognitive decline. That's our ability to identify scams and diminishes a little bit, it gets a little bit more complicated to understand things, then it's useful for those situations. You don't have to have it, but it is helpful if you are kind of experiencing a little bit of a cognitive decline. It is not, it's the first step that people look at to see if a guardianship is needed. So right, you're not permanently incapacitated. You still have to be able to make some decisions. It's less restrictive, and you are able to retain agency until full incapacity becomes a reality, if it does. The statutory durable power of attorney. At this point in time, everything gets split into two. We're going to have a set of documents related to financial and legal matters, and then we're going to have another set of documents related to medical. So that's what the split is going to be going forward. Statutory durable power of attorney names a person to make legal and financial decisions when a person's unable to do so. It is you are unable to do so in two different kinds of time frames. It's a choice of when it's effective. Immediately, it's effective immediately. So what does that mean? That means that you sign a power of attorney naming Bob as your agent. Bob can take that signed document, effective immediately, go across the street and open up a bank account or pay bills on your behalf. That is what effective immediately is. Then we have effective on springing, which is that after a doctor's consultation, a doctor has said that the person is no longer has capacity to make decisions on their own, and now the power of attorney is in effect, and there'll be a letter that gets attached with that, and that's basically what it is. There's no right or wrong on when you choose to do that. Um, it does depend on your situation. For a lot of people, I find that younger people tend to make it effective when it's springing. As a general rule, doesn't need to be. Why would you choose immediate over springing? You're removing the need for the doctor, right? For some people, it's like, well, I trust the person I've named. I don't think they're going to do anything, um, as long as I have capacity, but I want the convenience of it, right? Again, using my family as an example, I have a power of attorney for my mom because I do her banking for her. Like as I mentioned, right? She has full capacity. She makes all of her life decisions. She just hates talking on the phone to the bank. I get to have the privilege of doing that for her. And so and that's it. That's the only thing that she has me do with that, right? And so for me, it's kind of one of those things. If you already have a family member that's kind of helping you do some of these types of things, and and they're not next of kin where they're allowed to do that, or they're not a co-owner in the account that they can allow to be allowed to do that, then you might as well go have it effective immediately, because now you have a general document instead of having to call each financial institution to be like, hey, Bob's allowed to do this for me and that kind of stuff, right? Like you would have the one standard document effective immediately. But there's no right or wrong. I mean, there's plenty of people who are like, no, I only want it to be effective when I can't make decisions for myself, and then you're going to make it springing. So then that's okay. The question to ask yourself is that if you wanted to be springing because you don't trust the person not to do anything until you're not able to do something, to me, that's a question of whether or not you've chosen the right person to serve as your agent. If you're not sure that they're a person that you can trust with immediate authority, then you probably don't want them to have authority when you are no longer able to change your mind, right? And so, if that's the factor, right? If trust is a question, then you need to choose a different person. But otherwise, it just comes down to what do you want when you want it to be effective. And then when we're talking about legal and financial decisions, it's paying bills, dealing with retirement accounts. It also includes your digital assets, like having access to either cryptocurrency, having access to your cryptocurrency or your online photo album. And also that includes that type of thing. It's a whole list of powers. Excuse me. A medical power of attorney is what it sounds like. It's a person who makes medical decisions when a person's unable to do so. It is effective only at the time of incapacity. As long as you have the ability to make medical decisions for yourself, you will make your own medical decisions. There is no medical power of attorney who will come in and be able to override your decision as long as you have capacity to do so. So, of course, that means a doctor would be required, and a doctor would have to determine that there is incapacity. Sorry, I'm gonna try to get this cough out of my throat. So, key takeaway here, the minimum protections, I kind of talk about this. You must do something when a person passes away. When a person becomes incapacitated, you might want to consider it at that time too, but for the most part, it's when a person passes away. Everyone needs a will. Better to have a will and not need it than to need a will and not have it. And a well executed, properly drafted will make your life so much easier for your family upon death. Be sure that someone has access to the bank account. That can either be as a payable on death account, which is what I typically recommend for most people, or make them a co-owner. It's another way that you can do that. But be sure they have access to the bank account so they can make payments on while the probate process is happening. Basically, they can make the payments. And then with that, everybody, regardless of age, regardless of situation, you need to have a statutory durable power of attorney and a medical power of attorney. That is the minimum documents that you need to be protected. There's other documents that I'm going to talk about now, but at the minimum, you need to have a will, payable on death account, statutory durable power of attorney, medical power of attorney, and then you have your minimum coverage for protection. Okay. Right. Then you have these are good to have, and I recommend it if you can get them done, right? So designation of a guardian in the event of later incapacity. This is planning for permanent incapacity. So, right, when you're talking about a statutory durable power of attorney or a medical power of attorney, there's a possibility that it's also when you're just unavailable, right? Like it could be that, right? A person with an immediately effective statutory durable power of attorney, because they're like, you know what? I worked hard. I'm going to go on a 6-month cruise. I'm going to go travel the world. I need someone to take care of my house while I'm gone. Right? That would a statutory power of attorney gives them that authority to do that. Person is just off having fun on their cruise, right? So that's kind of like the situation on some of that. I always say medical power of attorney is when you're not able to make decisions, but why is that possibly temporary? A person can be in a car accident, they're unconscious when they come in and there's surgery, and then the doctor's like, I need some medical decisions to be made about how, we have 2 options available. What would you like us to do while this person's in surgery, right? So, and then when the person's out of surgery, when they have regained their consciousness and their capacity, they will make their own decisions going forward, right? So that's how a medical power of attorney can be temporary, and a temporary incapacity. So what we're looking at when we're talking about guardian in the event of later incapacity, we're talking about a permanent incapacity. We're not expecting the person to regain the ability to make decisions for themselves. And that's what this document does, is naming who we want to serve as our guardian in the event of of a permanent incapacity. Just as important for some people is that this document allows them to disqualify a person from serving as a guardian. So why does this matter? Unlike the other document with the guardianship, there's a court proceeding. You're going to go to court and you're going to have a court create a guardianship. The person who serves as the guardian must be eligible, must be appointed by the court. And there's different factors that come into that the court has to take into consideration in naming the guardian. One of those factors is this document. If you have a designation of a guardian event of legal capacity, they're going to look at that first person. They're going to look at the person named there, and they're like, okay, can this person serve? There's a lot of reasons why a person can serve. They themselves have become incapacitated. They may have passed. They may have moved, and they're no longer physically in the area able to take on the responsibility. There's lots of different reasons why they may not be able to serve, plus the things that disqualify a person. So if the first choice is not available to serve for whatever those reasons are, they go to the second choice. Then if the second choice, the alternate, is unable to serve for whatever they want, now they're going to go look at the next possible person. Typically, they're going to look at the next of kin. So if the first person was the spouse unable to do it, and for child, whatever, right? Now they're going to go look at the next of kin. And what if that next of kin is a sibling that you haven't talked to in 30 years? Y'all hate each other. Hopefully that's not the case, but like it's a family member that you don't have contact with, and you don't want them to serve. But according to the law structure, they're the next person, that's the next of kin that they would contact, right? They don't know. Right? Keep it right. The judge is a stranger to you, right? They don't know that you haven't talked to your sibling in 30 years and you don't want to have a relationship with them and you don't trust them to become your guardian for whatever reasons that there are, right? They don't know that. They just know that according to the law, the next of kin is the brother, and they're going to contact the brother. Well, with this document, if you can name someone, you can say, I don't want this person to serve. And so you're going to say, I don't want my brother to serve, because we haven't been, you don't have to give reasons, right? I don't want my brother to serve. The court will, at that point in time, take that into consideration. They will make sure that your brother is not the one who serves, and they will look to the next person that can serve as a guardian in the event that your first and second choice are not able to do that. So for some, that can be just as important as naming the person they want to be their guardian. And just like with the power of attorneys, there's one for the person taking care of making health decisions, where they're going to live, that type of things. That's the guardian of the person. And then for legal and financial matters, there's going to be the guardian of the estate. They don't have to be the same person. It is helpful for them to be the same person. That's fine. If they're not going to be the same person, just be sure that you know that they're going to get along, because sometimes financial decisions impact medical decisions, right? And so you want to be sure that they're kind of in sync with each other. A HIPAA release. HIPAA is the Health Insurance Portability and Accountability Act. It protects your private medical information, and it cannot be shared by certain people, not everybody, by certain people. And who are those certain people? Basically, it's mostly medical providers, right? Hospitals, doctors, nurses. It also applies to other people. It applies to lawyers. HIPAA applies to individuals who obtain medical information in the course of either treatment or in the representation of a person, and we cannot share that health information without the express permission of the person who holds that things. A HIPAA release gives that express permission to everybody. And so this is a general document. We do recommend that you do that. At a minimum, the HIPAA release should include your medical power of attorney and the person designated as your guardian of the person. So that way they can get access to medical information. The HIPAA release that you signed with your primary care physician only applies to that primary care physician. So a person cannot call them and say, "Hey, can I get a copy of your HIPAA release to be able to go to, my dentist and ask for their the dental records?" It's not going to work that way. So the HIPAA release is what ensures that the person who's making those medical decisions are able to go and get the information relatively easily. You can also include other people in that. At minimum, you want to include your power of attorney for your medical power of attorney and your guardian, but include anybody that you would want them to have access to medical information. They just won't be able to make decisions on it because they don't have that authority. An advance directive to physicians. This is commonly known as a living will. This is a directive that is talking about potential end of life care. It's a pretty heavy document, and it can be difficult for some people. Two conditions that we're talking about. One is a terminal condition, and this is defined as a condition that a person has that they're going to be expected to pass within 6 months, even with life-sustaining treatment. So an example of this would be an aggressive stage 4 cancer, would be an example of what could be considered terminal condition. An irreversible condition is one where the person is not expected to recover from, but itself is not a terminal condition. They can live in this irreversible condition, but they need intervening life-sustaining treatment. An example of this would be a coma. A person can live in a coma for years, but we have to have nutrition. We need to be fed. We would have to have artificial nutrition for a person in a coma. So that would be an example of an irreversible condition. For either one of these, for both of these, you're going to have there's a couple of options, which is stop treatment, keep me comfortable and let me pass peacefully. The other is to use all available life-sustaining treatment. And within that, you can also provide some specific advice, specific instructions. It's like, I want all life-sustaining treatment, but if you're going to have to put me on a respirator, then I want to be allowed to be passed peacefully. And so those kinds of situations can also be considered in that. It can be a decision by your medical power of attorney after conferring with a physician. So the standard form, the typical template, does not include that third option in there, the conferring with the medical power of attorney. I will say that typically they will contact the medical power of attorney. Most doctors are not just going to, take this document and make a decision on their own. They will confer with the medical power of attorney. This is a directive, right? This is just saying what you want. But it is possible to say that the medical power of attorney is the one who makes the decisions. Um, thing about that is I do recommend that you have these conversations with the people, with the person you're naming as your medical power of attorney. This is heavy, right? Chances are the person you've named is someone who loves you and cares about you very much. And you're asking them to make what can be a potentially very difficult decision on for someone that they love. And so do what you have to do. This is the counseling side of being a lawyer. Like maybe you need to have a counselor, or if you're a person of faith, maybe your faith organization has a person that can help kind of this conversation. Sometimes maybe forgiveness needs to be talked about, right? This can be a pretty heavy thing for people. It's be very hard for people to talk about. I've seen it where, I mean, when my mom was having this conversation with us, we were like, you're gonna live to be 150, right? Like we don't like so right. This can be very difficult to do. Um, so just be aware that you should have conversations to the best of your ability with your medical power of attorney, so that way if they are in a situation when they need to make a decision, that they have the informed information, right? That you have told them what you want and what the circumstances are, and also the understanding that you are asking them out of a loving place to make a decision that is difficult, and whatever forgiveness or understanding that needs to happen happens there. This does not replace a hospice plan. So if you go into hospice, hospice plan will govern over the advanced directive. We're almost done. Declaration for mental health treatment. This is a document that not everybody needs, is very specific, but for those people who do need it, is a very helpful document. It's also known as a Psychiatric Advanced Directive, a PAD. And what this is a documentation for people who are at risk or have a history of psychiatric hospitalization. An example diagnosis where this happens is schizophrenia. And so it's a mental incapacity, and it's temporary, but it requires a hospitalization. This document informs what types of decisions you can live with as it relates to psychoactive medication, convulsive therapy, and emergency mental health treatment. Unlike the other documents where you would be checking, making sure it's still up to date, do with the life changes and things online, this the Declaration for Mental Health Treatment does expire. It has to be re-executed every 3 years. But if you know someone who needs this, this is a very effective and important document. All right, last but not least, we're going to talk about long-term care planning very briefly. This on its own has its own, it could be its own lengthy presentation, but long-term care planning is is thinking about becoming eligible for benefits such as Medicaid and protecting assets from creditors, including the Medicaid Estate Recovery Program. MERP is what it's how you will hear it be talked about. We are an aging population that's living longer, and the estimates are pretty high that once you reach a certain age, that something like 80% of us will utilize long-term care in our medical care in our elderly years. And so when we're talking about long-term care planning, we're thinking about how to become eligible, and we're thinking about how to protect the property that we have worked for our heirs. And so for real property, one of the things that we can do is called an enhanced life estates, commonly known as a ladybird. That is something that can be used to become eligible, as well as protect the home from the MERP claim. And just to explain what the MERP claim is, so if you go into a residential facility, long-term care facilities, Medicare is not able to cover for the entire length of time. It's depending on the benefits and everything, between 3 to 6 months is how much Medicare will cover. At that point in time, if there's still a need for benefits, for government assistance, it becomes a Medicaid plan. And so when Medicaid becomes part of the long-term care payment, the state has the right to go to the estate and make a recovery claim, to reclaim from the estate the money spent for the long-term care. And so what we're thinking about is, how do we protect the home for our heirs as opposed to it being taken for the state. And so historically it was a Lady Bird estate is what people use, but the transfer on death deed also will protect the home. And so one or the other, there's factors on why one is better than the other depending on your situation. And so typically when long-term care becomes part of the conversation, it is worthwhile talking to an attorney about it, so that way you are making the right decisions on what to do with your home and transferring the home. For income, when someone is getting income, this is strictly about protecting it for eligibility purposes, and that is going to be a qualified income trust. So what will happen is that there will be a couple. One spouse now needs long-term care and needs to go on to Medicaid, but the other spouse is still working and bringing income, and the income that's coming into the house is preventing the spouse that needs the care from being eligible. That's basically what we're talking about. And then, so a qualified income trust, commonly known as a Miller trust, is irrevocable. Once it's done, it's an irrevocable trust, but then it protects the income, allowing the eligibility for the spouse that needs, so one spouse can continue to work while the other spouse becomes eligible for Medicaid. Again, with this, when you were talking about this, because there's some nuance to it, as you're kind of approaching this, it may be worthwhile to talk to an attorney to be sure that you're putting the right planning into place, because sometimes some of this stuff, once it's put into effect, is really hard to undo. So you want to be sure that you have the bad news attorney on, looking at potential bad news. We're only bad news because we're trying to stop a problem before it arises, right? Okay. So what's next? You're going to create a list of accounts. Unfortunately, that's not something your attorney is necessarily going to do. Now, what I do is that I have a questionnaire that is overwhelming. It's like 20 pages long. But it serves two purposes. One, the questionnaire gives me the information I need to be able to draft the documents for my clients, in my case, volunteer attorneys who draft documents our clients. But it also serves this other purpose, which is that your executor and your beneficiaries know what you have, right? So if you have three life insurance uh, uh, accounts, well, do does your executor know that? So this is so my questionnaire serves as that purpose as well, so that you write down all your bank accounts, your credit card companies, your mortgage company, like it's all then some written in one place, so that, and you're going to keep that with your documents, so that way when the executor goes to the attorney, they can take all of that with them, and the attorney will be like, oh, okay, we now know what credit cards we owe, we know like where the life insurance policy is at, and to be able to kind of do the steps that need to kind of be done. So you're going to create a list of accounts. One of the things you should also consider in that, digital access. There's lots of different ways that you can do that. You know, and some people have a password manager that's shared with the executor, and that's how they are able to get access to all of the online accounts and things like that. So that's one way of doing it. It could be that it's a shared account and they can both log into it. You can give them their passwords and things like that. Just kind of think about like, how can they get access to your digital accounts. I actually had a unique situation where we had to go figure out how to do this, which was that a client who passed had a cryptocurrency account, but it was only accessible via the person's cell phone, an app on their cell phone, and we had to get a court order to unlock the cell phone, and name the person as the beneficiary on that. So right, like, so that was an unusual situation. I don't know how frequently that pops up, but think about that kind of stuff, right? Like your digital access. Um, then then you're going to want to keep it into a safe space. So what is that? Like, where do you want to keep all of this, right? Safety deposit box is usually something that people will think of. That is obviously a safe space. Be aware though, in order to access a safety deposit box, you must be both an owner on the account and a key holder. So if you're going to do that, be sure that the person is an owner and a key holder. Otherwise, it does require a court order to open up the safety deposit box, and only the executor can take the will. It's just an examination, and only but the will would be left there. But there's also all the other documents, right? Like, how would you get access to that, right? If they can't get access to the safety deposit box. The county clerk, sometimes I get asked about that. Like, oh, if I write my own will, do I have to like mail it to myself, like file it somewhere? No. An effective will is handwritten 100% in your own handwriting, signed and dated, or a typed will, signed and dated with two witnesses, signed and dated it, and then hopefully with self-proving affidavit. There's no requirements to mail it anywhere, to file it anywhere, for it to be a valid will. You just need to have the original will that has not been destroyed or marked up or anything like that, with the documents. But you have the option, if you wish, you can file your will with the county clerk, and they will send it back to you, and that becomes a certified copy in the event that the will is lost. So it's an extra thing you can do, just not required to do so. So what do I do? It's just with your important papers. Like, where do you keep your passport, your social security card, birth certificates, right? Like, I live in Houston, and so like, right, part of the things that you think about is hurricane readiness, and so we have like a go bag, right? Like you have like, where you can grab your important documents if you should need to evacuate, and so things like that, right? So we have a document lock safe, right? And we both have access to the account, right? Like to the thing. So like things like that, right? You can do that. I would not put it into your freezer. I get that. It's like, oh, should I just freeze it? No, please don't. I am so nervous of putting any kind of moisture near important papers. But be sure it's just, you don't want it laying about, but secure and easy but accessible to the people who need to get access to those documents. Let your executor know or your agents know where those documents are so that way if they do need them, they can go get them. And then you're going to discuss with your representatives and the family about what's in those documents, why the decisions have been made, so that way they are also informed about that. Okay. So just to reiterate the key takeaways, because again, this is a lot of information. You need to do something after a person passes away, which is go talk to an attorney. Take those papers, go to talk to an attorney. Everyone needs a will. Better have a will and not need it than to need a will and not have it. And a properly executed, well drafted will make the probate process significantly less expensive and easier to complete. Be sure that there's access to the bank account, either through a payable on death account or a co-owner, because the bills still need to get paid until the property is handled, either via probate or transfer on death options. Um, and then everyone at the minimum needs a statutory durable power of attorney to allow a person to make financial and legal decisions in the event of your incapacity, and a medical power of attorney so a person can make medical decisions in the event of your incapacity. That's the minimum protections. This was a lot. You don't have to go it alone. I know it's been like, oh my gosh, it's been like an hour and a half. Jesse, I forgot all about who you are. We are available to assist for those people who are eligible for services. I am with Lone Star Legal Aid, obviously, so that's my information there. But we have two other legal partners in this partnership, which is Houston Volunteer Lawyers and the Earl Carl Institute. I say apply to whoever you would like to apply to, or all three, whoever can get to you first, maybe. Don't assume that you don't qualify for services automatically because you may be surprised that you do. Now, if you know you don't qualify for services and you want to hire an attorney, the Houston Lawyer Referral Service is a service of the Houston Bar Association, and you can contact them, and they will give you the name of two attorneys that practice in the area that you can go make an appointments with. Usually, there is either a $0 consultation or a $20 consultation. Some attorneys do offer a sliding scale fee based on ability to pay, but these are the private bar. You are paying them for their time and their services. I cannot recommend anyone specifically. If you do not live in the Houston area, you're watching this someplace else, the Texas State Bar has a similar referral service, and you can check them out there to get a recommendation in your local area. And then last but not least, for those of you who are going to try to move forward on your own and do it pro se is doing it yourself. Texas Law Help is a great website. It's texaslawhelp.org. Not only for estate planning, there's lots of information on many different areas of the law, housing, family, bankruptcies, you name it. You can typically find the information there. At Texas Law Help, you can also find access to not for a will, but they have in an interviewing kind of system where you put in the information and it will print out for you as durable power of attorney, a medical power of attorney, and an advanced directive. I think that's all the ones that it can do that there. But again, you're going to get a copy of all of the templates in the email after this. And so there is options available to you. I know this is a heavy topic. I do try to put things light-hearted as I can. So I always end my presentations with a joke. And in this case, we have Miss Chicken here, she with her an attorney, and she says, I want to leave all of my estate to my sister, but if she's not living, then in trust for her eggs. So with that, we are now at question time. So if you have any questions, I didn't see any in the chat, but if anyone has any questions, feel free to either, excuse me, mute yourself, or for those of you online, remember, no private information, no self-identification, the internet's forever. But Miss Neo is checking the comments online, and then for those of you in the room, you can raise your hand and she will monitor the questions at this point.
It's very rare that we don't actually get questions in the chat at all,
I know.
but that's okay. Do either of you have any questions?
I have three children. I have checking account and I have savings account. I don't have no property like land and houses and anything like that.
Okay.
But I'm looking at the form, it says pay on death, so I just had all three of those kids, the sign, some document at the bank, so the day that I deceased, that bank will just give that money to them dollars.
They don't have to sign. You need to go to the bank to sign. She's asking for clarification on payable on death beneficiary when there are multiple children. If she's got three children,
Mhm.
They're not gonna apply for another. We already discussed all.
so when there are multiple children in this example, three, and there's a payable on death, she wants to add a payable on death beneficiary for her bank account.
Mhm.
Is it equally split?
Yeah,
between
it's
all
equally split.
three?
Yeah.
There are no instructions or anything like that that need to go with that.
No. On those,
No.
it's going to be now. There may be like on the beneficiary, like for I have to double check this. I know for a fact for retirement accounts and for life insurance policies, you can change the percentages, where it's like 50% to one person, 25 to this person, 25 to another person. Like you can do that on retirement and life insurance proceeds. I believe you can do it on payable on death accounts for bank accounts and savings accounts, but I'm not 100% sure. If there's not, then it's equally split among the people named. I think it might depend on the bank as well. So.
Because I've seen some banks where they put all three children on one check, not like
Yeah, they've done that too, and that can be
they
complicated.
all three have to sign the check to be able to cash it kind of thing. But it
Yeah,
depends on your bank, like she said. So
it does depend on the bank, yeah.
And I do have, I have in the apartment, which I live there, but I have two bills that they both paid off. My son is a taco. So my son
not
is
not too much information though. We don't want to. Okay,
No,
this that's okay.
well, but the way things are going, my three children, because I saw what happened with my mom died. So,
And the thing is, and that I want to say this to everybody else that's listening, grief has a different way, a different kind of way of showing up. So as much as you think your children may get along right now,
Mm,
it does not matter. It still needs to be put in place, and things need to be, everything needs to be put in place so that way there is no misunderstandings. There is no opportunity for there to be, the rift between who gets what, who says what. She told me this, she said that. Get it all written down, because we have seen over the last, since we've been doing this in 2017, 2018, we have heard some horrible stories from people about, what wouldn't happen or what they didn't think was supposed to happen or going to happen, and it does happen. So again, as much as you would like to think your children get along, then they may do, and there may not be any issues, but just to be on the safe side, make sure everything is in place.
and
mhm.
looking at something here, durable,
Power of attorney.
yes.
Hmm.
What is that?
It's just the power of attorney. It's the same. I'll, when, after this presentation, again, the templates and everything will be mailed out to you. So it'll have a copy of what one looks like. So for everybody else as well, a copy of the templates for every document that she went over will be going out so that you guys can see. And, it kind of gives like a little brief description or like a little instruction, this kind of goes here. This is what goes here. And this is what this form looks like and what you need to do to make sure it's properly executed.
So for all three of these here, The Lone Star, I don't know if I'm gonna get to it, I never did before, it's the Lone Star Legal Aid, Christian Volunteer Right. These, so they're on charge, these are volunteer ones. Like,
Correct.
so I can apply for all three.
You can,
And then I can talk to them.
you can apply for all three service, all three, if you'd like, yes.
This is so interesting, I'm not, oh, the deaf, okay, advanced planning program. I
So
haven't did a program though, I mean, you know, just. Cause I don't have no man, house and stuff like that.
Well, if you fill out a will, if you have a will that you create, the will have to be probated,
Yeah.
period. In order for them to get the ownership, it's the will's got to be probated.
Yeah.
Okay, so
This is awesome right here.
the links for each of our legal partners, the websites, all that information is going to be distributed and sent to you guys. Did you put your email address on the sign-in sheet? I think we've got it in here.
Okay, I want to make sure the emails come back.
Okay.
Mine.
Okay, so again, a copy of the recording is going to go out, a copy of the templates for all of the documents that she went over, the resources, the links for their websites going to be included. And is there anything else? I can't think of anything else that I'm forgetting. The resources, the templates, and the recording. All three of those are going to go out, so you guys are going to get all of those. I believe that is it. We've only got one more presentation that's scheduled for the remainder of the year. Next week, that will be our property tax workshop. You know, property tax bills have gone out, and lots of people have gotten questions about those and about the exemptions and the increase in the school tax exemption. All of that's going to be reviewed in our presentation next Thursday at 1 p.m. So you guys can tune in for that one if you need more information about that. We'll be starting back over in February. There's a couple of little workshops that we've got scheduled for January, but I mean, but we generally don't. We start off at the 1st of February, that first week in February. So yeah, I believe that's it. So we won't be back until then. We'll see you guys until next year potentially. So we hope you all have a wonderful holiday season. You all take care. You all stay safe. If you have in the meantime any topics that you may be interested in for 2026, please feel free to reach out to us and let us know. So as we're planning the calendar, the schedule for 2026, we can keep those topics in mind as we are planning. So thank you, Jesse. Get you some water because that was a lot of information that you covered. Because I can imagine what your throat feels like right about now. So
yeah. Well, thanks everyone. I hope everyone has a fantastic holiday season.
All right, you all take care. You stay safe, and we will see y'all next time.
Give me my order.